This one is about citizenship. Do you know who you are? Copies of these documents can be found in my private group at Yahoo called Administering Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but for all the revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966, as an extremely less desirable alternative, I can accept the IOUs, the commercial paper, the Federal Reserve notes, PayPal, gifts, checks, money orders, etc. Send me an email for particulars. So, the question is, where does sovereignty come from? Sovereignty exists because of common law and the law of the land, which has always been here and it will always be here. There's nothing they can do about it, and it's in every country on the planet. The people in all countries with the common law of England owe their sovereignty to the common law, but it's actually, according to what legal writers, scholars have said, it's in every country on the planet. Canada, United States, Australia, New Zealand, all common law countries in the world, we the people are the sovereignty. So what is a sovereign? A sovereign is the right to rule. A sovereign can be a king or queen. A sovereign can be a group of people. And a sovereign can be a living soul. Sovereign, the chief ruler with supreme power, a king or other ruler with limited power, and action is not maintainable against a foreign sovereign. And this is Declaration of Independence, 1776. When in the course of human events it becomes necessary for one political to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. And we hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And this is the preamble of the Declaration of Independence, and then it goes into a list of grievances, basically. And the point I want to point out, or the stuff I want to point out in this particular slide, is the law of nature, nature's God, and endowed by their Creator. So we're going to see where those phrases come from, especially nature, nature's God. It's actually taken, Jefferson's the one that wrote the Declaration of Independence, and he took it from a set of books called Blackstone's Commentaries on the Laws of England that were written during that time period, actually just previous to that time period, 1769. I guess the set of books was written 1765 to 1769. There was 4 volumes. Anyway, section 2, page 41, and volume 1. It says, this law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe in all countries and at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority immediately from this original. So again, it all goes back to the law of nature, okay? And it's always been here and it will always be here. This is same thing, Blackstone's Commentaries. It continues. This is given manifold occasion for the benign intervention of divine providence, which, in compassion to the frailty, the imperfection, the blindness of human reason, hath been pleased at sundry times and in divers manners to discover and enforce its laws by an immediate and direct revelation. The doctrines thus delivered we call the revealed or divine law, and they are to be found only in the Holy Scriptures. These precepts, when revealed, are found upon comparison to be really a part of the original law of nature, as they tend in all their consequences to man's felicity. So now we're talking about the fact that the law of nature, part of the law of nature is, you know, if you pick something up like a rock and you drop it, it will fall. Okay, now with anti-gravity, I guess that doesn't necessarily hold true, but generally speaking, that is the case. Now, so that's the law of nature, part of it, and part of it is found in the Scriptures, okay? Upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human law should be suffered to contradict these. That's on the following page of Blackstone's Commentaries of Laws of England. Every citizen and freeman is endowed with certain rights and privileges to enjoy, which no written law or statute is required. These are the fundamental or natural rights recognized among all free people. So, if they are assaulting you, then are you free? And if you're not free, then what are you going to do about it? You know, we the people, the purpose of these videos is to educate people about what's going on, because the people need to put a stop to what's going on right now. And I think it started with the new guy in the White House, but he's just one guy. Okay, we the people still need to get off our backside and take care of business. As a general rule, men have the natural right to do anything which their inclinations may suggest, if it be not evil in itself and in no ways impairs the rights of the others. It's all talking about natural law. Don't forget to like this video. Don't forget to subscribe to this channel. And don't forget to click the bell next to the subscribe button so that you're notified when there's a new upload. There's the front page of my channel, and the arrow is pointing at the bell. A little pop-up will come up, and you'll have to check a box saying you want to be notified. Sovereignty is the right to govern. A nation or state sovereign is the person or persons in whom that resides. And that's Chisholm versus Georgia. That's like 1793. So who are the sovereigns? In a common law country, the people, the sovereigns are the people. That's where we have the law of nature. The law of nature is everywhere. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form a sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of the sovereignty. And that's Dred Scott versus Sanford, U.S. Supreme Court. The sovereign people, through their representatives, have created the court and the board as well as the municipal council and have defined the rights and duties of each. This is a Canadian court case. Okay, reference Casa Loma, that's in Toronto, Book 4 of Dominion Law Reports, 1927, the Supreme Court of Canada again. This is the Parliament of Canada and the legislatures of the several provinces are sovereign within their spheres defined by the British North America Act, but none of them has the unlimited capacity of the individual. And so they're saying that the people are sovereign. Okay, and this is the Lord Nelson Hotel case, the Supreme Court case. And that's actually, that's the chief judge at the time. Anyways, this is an Australian court case. Translated into constitutional terms, it denotes that the sovereign power which resides in the people is exercised on their behalf by their representatives. Basically the same thing. The powers of government in this country are derived from the people who are the ultimate sovereign. Okay, another Australian court case. English court case. Every individual was sovereign over himself. Okay, so this is nothing that's unusual, you know. One time I was in Toronto and I was preparing an appeal brief at this office supply store, making copies and stuff like that, and this lawyer showed up and he was looking at my stuff and it had Ontario Court of Appeals written all over it, and he said, oh yeah, he says, so what's your case over? And I said, it has to do with sovereignty. He says, oh yeah, everybody knows that people are sovereign. I mean, everybody knows that has any knowledge. Yeah, absolutely. But people get dumbed down and they don't get educated about it, and they get treated like a slave. That's really what it comes down to. And the only reason that they're getting away with it is because you are letting them get away with it. We the people are the kings and queens. The people are sovereign, are not bound by general words and statutes restrictive of prerogative, right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. And that's Supreme Court, New York Supreme Court case. We the people are kings. Okay, at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. And that's again Chisholm versus Georgia. people of a state are entitled to all the rights which formerly belonged to the king by his prerogative, it will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective states. It's a foregone conclusion. Okay, this is all Supreme Court cases. This is a Jacob A. New Law Dictionary, 1750. This is nothing new. Citizens of London are either freemen as such or such as reside and keep the family in the city, etc. And some are citizens and freemen, and some are not, who have not so great privileges as the others. The citizens of London may prescribe against a statute because their liberties are reinforced by statute. In other words, statutes don't apply to we the people. Okay, the statutes are there to protect our rights. That's the only reason they're not there to take away our rights. If we get mixed up in one of these statutes, that's because we volunteered in. That's exactly right, okay? And we, the people, need to learn how to quit volunteering. Governments are but trustees, acting under derived authority, and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. And that's U.S. Supreme Court again. Okay, it's delegated. The only power the government has was delegated. Do I have power to take your property and give it to your neighbor because he does not have food to eat or for any other reason? If I do not have that power, then neither does the government. If the government is doing anything like this, then it's because you've consented to it. That's exactly what's going on. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. Another Supreme Court case, Yickwo versus Hopkins. Do you know who you are? Delegated powers to a trust. There is no such thing as power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not by their Constitution entrusted to it. All else is withheld. So, again, the Constitution is a trust indenture. That's exactly what it is. It sets up a trust. The land patent is the minument of title, such title being absolute in its nature, making the sovereigns absolute freeholders on their land. Finally, the patent is the only evidence of legal fee simple title. And the reason I'm bringing this up is because many extremely ignorant people run around claiming that, and mostly like bar member trolls, quite frankly, run around claiming that sovereignty is held by the group and not individually. Well, that's wrong, okay? Each of us individually are sovereign. I was visited by the FBI and the Texas DPS in March of 2011, and they told me at that time that I am listed as sovereign in their system. Now, certainly, Obama made war on anybody that thinks they have any rights. There's no doubt about it. But again, he needs to be sued, doesn't he? Because that's a violation of their UN international agreements under their international covenant on civil and political rights, the right to hold political beliefs. Okay? And so, but the law says that you are sovereign. Okay? So do you know who you are? That's the question. You can go ahead and bring up about this stuff about Obama's making war on sovereigns, and it's true that a couple people went out and read a few court cases and thought that they were sovereign and thought they could go and get in a gunfight with the police. Well, you know what happened to them, don't you? And so based on that, Obama decided to go out and make war on anybody that thought they had any rights. It's exactly, and he also made war on preppers. He also made war on Christian fundamentalists. He also made war on a lot of people. But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government, and interfering with their relation to each other. The powers of the government and the rights of the citizens under it are positive and practical regulations plainly written down. The people of the United States have delegated to it certain enumerated powers and forbidden it to exercise others. Again, that's Dred Scott versus Sanford. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people, from whom the government emanated, and they may change it at their discretion. Sovereignty then in this country abides in the constituency and not with the agent, and this remark is true both in reference to the state and federal governments. A delegate cannot delegate. An agent cannot delegate his functions to a subagent without knowledge or consent of the principal. The persons to whom an office or duty is delegated cannot lawfully devolve the duty on another unless he be expressly authorized to do so. So the point being is that corporation that's operating in District of Columbia called United States has no authority. Okay, that corporation called Central Intelligence Agency, that one doesn't have any authority. That corporation called Federal Bureau of Investigation, that one doesn't have any authority. That corporation called Internal Revenue Service, that one doesn't have any authority. None of them have a shred of authority because it doesn't say anything about it in the Constitution. And that's a maxim of law. A delegated power cannot be again delegated. A deputy cannot have or appoint a deputy. The power which is derived cannot be greater than that from which it is derived. And that's Bouvier's Law Dictionary. These are all maxims of law. And those corporations called U.S. Court of Appeals for the Ninth Circuit, okay, that has no authority, okay? It's a legislative court that's created by Congress is what it is. And it can only make advisory decisions. There's court cases that talk about it. These people are Satanists. You're never going to get justice at the hands of these Satanists. It is true that at common law, the duty of the Attorney General is to represent the king, he being the embodiment of the state, but under the democratic form of government, not now prevailing, the people are king, so the Attorney General's duties are to that of sovereign rather than to the machinery of government. Okay, and you need to point that out to the Attorney General. I'm going to actually point that out to the Attorney General next time I send him a letter. And now another little diversion. And they seem to come along about the right time because I can chill off a little bit. Anyways, announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 a month because it avoids the advertising only. Originally, when I set up the channel, I was planning on having some exclusive content, and I do actually have a little bit of exclusive content. And it's up to you whether you want to subscribe to it or not. What I might suggest is if you like what I do, then I might suggest that you might want to subscribe just to make a donation and to be notified of when you get uploads or you get new uploads, because there is some exclusive material. There is actually, I've uploaded recently one on affidavits and how to build an affidavit, build a case against people, and there's also an Arlington private information share that's on there exclusively, and there's going to be some more in the future, but the only thing that I can really guarantee is that there's no advertising. So for $1.99 a month, you don't get any advertising. Anyways, I'm currently publishing 5 videos a week, and some people had some difficulty finding the channel, so a link to it's at the bottom, and then there's also a link to it at the top. And also somebody sent me a donation for $1.99, but I wasn't sure if it was a donation, if they wanted me to sign them up. And so I actually sent them an email and asked them if this was supposed to be a donation or if they wanted me to sign them up, because I have no control over signing anybody up. I have absolutely no control of that. I can't even see all the subscribers. I can see some of them, but I can't see them all. And so I have no control over that. If you want to sign up, you got to click the Start Free Trial button and go through what YouTube wants you to do. I'm sure they're probably going to want some payment arrangements or who knows what. Anyways, back to the topic at hand. The law of Congress do not extend into territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. And that's U.S. Supreme Court. The exclusive jurisdiction which the United States have in forts and dockyards ceded to them is derived from the express assent of the states by whom the cessions are made. It could be derived in no other manner, because without it, the authority of the state would be supreme and exclusive therein. Again, that's U.S. Supreme Court case, both of those. The Magna Carta is called the Great Charter of English Liberty. The Canadian Handbook for Judges cites the Magna Carta on page 77. It says, Magna Carta says, will not deny or defer any man either right or justice. And actually, it doesn't say that, but it's close enough, I suppose. And this is a Quebec court case. The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between two legitimate and independent sovereignties, nor between two nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between two nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. So the point being is, what they did is they went and did what happens in so many other cases, is they got the king, they stuck a sword to his throat, and they said, here, king, we want you to sign this, and you either sign it or we're going to run you through right now. And so he signed it, obviously. And that's a Quebec court case located in the book 4 of Dominion Law Reports, page 147, Perlman versus Pichet. Anyways, and it's reference a habeas corpus, which they say Quebec is under civil law. Well, doesn't matter. Common law is there. Common law of nature is always there, and it will always be there. Anyway, so why do we, the people, set up governments in the first place? We set up governments for protection against foreign enemies, for protection from each other, for protection to administer disputes in a fair and impartial manner. And the only legitimate function for government is to protect the rights of the people. It's a protection racket, is what it is. Okay, that's what it is a protection racket. And so the hierarchy of things is, you have God, who's the King of Kings. He created we the people. We the people created the government, and the government created corporations. And the created can never be greater than those who created. Okay, when you're created, you can never be greater. We can't expect to do anything with God. Okay, he's not going to he just ignores us, and the government has nothing to say to we the people. And so why is God in the Constitution? Is because our rights come from God. You know, these in Canada, especially the communists, like to say, well, we want to take God out of the Constitution. Yeah, I understand how the communists would want to do that. And because if they can take God out of the Constitution, then all rights come from the government. Okay, and so our rights come from God. Only God can take them away. This is Hale versus Hinkle, another U.S. Supreme Court case. The individual may stand upon his constitutional rights as a citizen. He's entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom, okay, beyond the protection of his life, liberty, and property. Okay, so there's the contract, if you think about it. We created the state, and they have to protect us, but that's it, okay? If you go to the state for anything, it becomes a contract, okay? His rights are such as existed by the law of the land, long antecedent to the organization of the state, okay? And so the law of the land was here before the state was here, and it'll be here when it goes away, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a judicial power warrant, a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. And now another little diversion, CubeYard.com. For great custom websites, domain names, and hostings, go to CubeYard.com. Use coupon code CY172 for 20% off your first order. CubeYard.com, your source for websites, domain names, and hosting. So, there's actually two classes of citizens. Two major ones, okay? There's a lot of them, actually. But there's two major classes of citizens, state and federal. And those are the ones we're going to talk about today. There is in our political system a government of each of the several states and a government of the United States. Each is distinct from the other and has citizens of its own. That's U.S. versus Cruikshank, U.S. Supreme Court. One may be a citizen of a state and yet not a citizen of the United States. That's McDonald versus State. There is a clear distinction between national citizenship and state citizenship. Teixeira versus Jordan, U.S. Supreme Court. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. And that's Jones versus Timmer, 1993. Citizenship of the United States does not entitle citizens to privileged immunities as citizens of the state, since privileges of one are not the same as the other. And that's California Supreme Court. The privileged immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. Okay, so a U.S. citizen doesn't have any rights, basically. If you want to be sovereign, you have to be. You gotta quit giving them evidence of that U.S. citizen slave. That's what it comes down to. Such construction ignores the rights of a state in virtue of its sovereignty to confer citizenship within its own limits, where the rights incident to such a status are not the citizenship mentioned in the federal Constitution. It does not follow that because one has all the rights and privileges of a citizen of a state, he must be a citizen of the United States. Such a distinction has long been recognized in this country. And that's, again, Mitchell, Mitchell versus Wells, okay, citing the U.S. Supreme Court. The rights of original judicial citizens of the states as such are not under consideration in the 14th Amendment. They stand as they did before the 14th Amendment and are fully guaranteed by other provisions. So, and what they're saying here is they don't, the 14th Amendment means absolutely nothing to state citizens. Actually, everything current 13th Amendment and after mean nothing to state citizens. Civil rights are under the 14th Amendment are for federal citizens and not state citizens. Federal citizens as parents have no right to the custody of their infant children except subject to the paramount right of the state. And see, the so-called 14th Amendment is unconstitutional video because it's actually a revision. That's why it's unconstitutional. So in Canada, it's the same. Okay, the same thing exists in Canada. The charter adopted in 1982 refers to citizens of Canada several times. That's federal citizens. The courts have told us the laws of Canada are federal laws. Citizens of Canada are federal citizens. Canadians include state, which is provincial citizens, and federal citizens. State citizens and federal citizens. Matter of fact, you see the Supreme Court when they're talking Alberta, they always talk about, or any of the so-called provinces, they talk about the state. Every citizen of Canada, and that's Section 3 and the Charter of Rights and Freedoms, Section 6.1, 6.2, 23.1, 23.2, and 23.3. They all talk about citizens of Canada. Section 3, every citizen of Canada has the right to vote in an election of members of the House of Commons and a legislative assembly to be qualified for membership therein. So you buy into their corporate status is what this is. Sestake trust is what it is. Notwithstanding anything in this charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. Okay? See, male and female, those are all operative words. Okay? That's all in the matrix. Okay? It's a man or a woman. Okay, at common law. This is People versus De La Guerra. It's just a California 1870 court case. It is evident that they have not the political rights which are vested in citizens of the states. They are not constituents of any community in which is vested any sovereign power of government. Their positions partakes more of a character of subjects than of citizens. They are subject to the law of the United States, but have no voice in its management. If they are allowed to make laws, the validity of these laws are derived from the sanction of a government in which they are not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. Okay, and so they're talking about U.S. citizens. That's why the elections mean absolutely nothing. Okay, it's a charade. They just rig the elections. And subject national, a citizen may indicate being a member of a sovereign state, especially one showing democratic forms and usages, owing it allegiance, sharing in individual political rights. Subject may imply a state of subjection to a person, such as a monarch, without much sense of membership in a political community or sharing in political rights. National, a more general word, may apply to anyone owing permanent allegiance to a nation and indicates one belonging to a broad category that includes both people who are legally citizens or subjects and also people who have not attained to such legal status. Okay, they're talking about a contract. Okay. And so, and you don't want to be involved in those contracts, is what it comes down to. Subject, constitutional law, one that owes allegiance to a sovereign and is governed by its laws. The natives of Great Britain are subjects of the British government. Men in free governments are subjects as well as citizens. As citizens, they enjoy rights of and franchises. As subjects, they are bound to obey the laws. The term is little used in this sense in countries enjoying a republican form of government. Yeah, that's because the citizens in the United States are actually subjects. Okay, so they don't bother with the term subjects. You might figure out what's going on. In our opinion, it was not the intent of the legislature to restrict the operation of the statute to those only who were subjects to the United States government and exclude therefrom unnaturalized residents of foreign birth, whether black or white. Okay, and this is Proud versus Gore. And so, upon the other hand, the 14th Amendment, upon the subject of citizenship, declares that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Here there is a limitation to person born or naturalized in the United States, which is not extended to person born in any place, okay, subject to their jurisdiction, okay? And this is Downs versus Bidwell. And so, again, it's all talking about a contract, okay? And the birth certificate is the big one, okay? Your parents are like brain dead for getting birth certificates. The persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject, okay? And that's Elk versus Wilkins, 1884. And I've got another cite from that case here. Oh, here it is right here. Merely being native born within the territorial boundaries of the United States of America does not make such an inhabitant a citizen of the United States subject to the jurisdiction of the 14th Amendment, okay? And there you go, okay? You do not have to be a U.S. citizen. There's nothing saying you have to be a U.S. citizen, okay? There is in our political system a government of the several states and a government of the United States. Each is distinct from the other and has citizens of its own. And this is Downs versus Bidwell again, dissenting opinion of Justice Marshall Harlan. Two national governments exist, one to be maintained under the Constitution with all its restriction, and the other to be maintained by Congress, outside and independently of that instrument. Why do you think that Nancy Pelosi, as Speaker of the House of Representatives, says they have to pass legislation so they can find out what it says? Well, you think that's the de jure government? Of course it's not. That's the reason that John Roberts can say, well, it's just another tax, because it's the government that's for District of Columbia and the territories only, and you have to volunteer in. Okay, that's exactly where it comes from. Did you give up your God-given rights for some satanic privileges? And now another little advertisement. Check out my other videos: Bankster Thieves 1, 2, and 3, Churchianity Series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do-It-Yourself, How Not to Volunteer for the Selective Service of the Draft. Martial law is here. Do-it-yourself no income tax, do-it-yourself estoppel certificates. Everything is an illusion. Void judgments, do-it-yourself kangaroo courts 1 through 9. Check them out. I think you'll find them interesting. The term citizen in the United States is analogous to the term subject in the common law. Okay, so that's what they did, is they took all the subjects and turned them into citizens to, a second-class citizen. U.S. citizens can murder their unborn children. The unborn are not included in the definition of person as used in the 14th Amendment. Okay, that's exactly what that celebrated Roe v. Wade case said. And while the 14th Amendment does not create a national citizenship, as it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. In other words, 14th Amendment turned citizenship into the opposite of what the Founding Fathers intended. But again, it doesn't affect the state citizens, okay? But the question is because everything's under martial law, they just presume you're one of the slaves. See, the so-called 14th Amendment is unconstitutional video. And the reason it's unconstitutional is it's a revision. Citizenship is a political status and may be defined and privilege limited by Congress, okay? That's for federal citizens, okay? The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. Again, that's federal citizens. The 14th Amendment referred to slavery. Consequently, the only persons embraced by its provisions for which Congress was authorized to legislate in the manner were those then in slavery. And no white person born within the limits of the United States and subject to their jurisdiction or born without those limits and consequently subsequently naturalized under their laws owes his status to the citizenship of the recent amendments of the federal Constitution. Now, I want to say something right here. I guess I'll say it right here, is that the Roman cult set up the slavery scam to basically, because they had ultimate objectives to destroy this country, is what they did. Okay, that's exactly what they wanted to do, is they wanted to destroy this country because these two classes of citizens, I don't care what race you are, everybody is sovereign, okay? But what happened was they went and gave license to Portugal and these countries to go and start enslaving people all over the place, and you see what's happening today because of it. And so that's all coming from the Roman cult. I've got other videos about the Roman cult, and I definitely do not agree with slavery in any form, no matter what race it is, and everybody's sovereign. Okay, and but because of the slavery issue, it has caused no end of grief, and it's going to continue to cause grief too. All citizens of the United States shall have the same right in every state and territory as enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. And that's in United States Code to this day. Look it up. 42 United States Code, Section 1982. So a U.S. citizen really is someone that's not white, okay? And I disagree with that. Well, actually, I completely am opposed to that. They're basically granting people rights. Those are government rights, and they actually have natural rights, okay? They have natural rights. They're all sovereign. They don't need their government privileges. Slavery was brought into America by the Roman cult to create the mechanism by which everyone would become enslaved. That's exactly what's happened. When the rights of the least of us are violated, we are all diminished. Okay? None of us should tolerate any of this. Al Capone was a gangster in Chicago during Prohibition. Everybody hated him because he was a gangster. Well, think about it. Al Capone was the first guy who was jailed for tax evasion, and now they jail all sorts of people for all sorts of so-called crimes, okay? So they go and take this evil bad guy and violate his rights while the rest of us sit there and let it happen, and then they use that precedent to go ahead and start violating everybody else's rights. So again, when the rights of the least of us are violated, we are all diminished. See the debtors' prisons are everywhere video. Therefore, the U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident, does not have the common law right to travel of a citizen of one of the several states. After the adoption of the 14th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the major purpose of which was to secure to the recently freed Negroes all the civil rights secured to white men. None other than citizens of the United States were within the provisions of the Act, and that's U.S. Supreme Court. All of these statutes are a cheap imitation of common law that essentially convert rights into privileges. And this is a cite from the book called The Non-Ratification of the 14th Amendment by Judge A.H. Eller to the Utah Supreme Court, which is associated with the case Diet versus Turner. By this means, citizens' birthrights become of no effect and their rights are reduced to the inferior character of statutory civil rights, which are mere legislative privileges. At common law, our rights are absolute rights. Statutes can and are changed. Statutes are even ignored sometimes. A subject, one who owes allegiance to a sovereign, is governed by that sovereign's laws. Speaking generally, we may say the terms subject and citizens are synonymous. Subjects and citizens are alike. those whose relation to the state is personal and not merely territorial, permanent and not merely temporary. Though this equivalent, however, is not absolute, for in the first place the term subject is commonly limited to monarchical forms of government, while the term citizen is specifically applicable in the case of republics. And so that's the difference, okay? Subject is a monarch, and citizens is a so-called republic, okay? And that's Black's Law Dictionary, 8th edition. Finally, it is to be noticed that the term subject is capable of a different and wider application in which it includes all members of the body politic, whether they are citizens, in other words, subjects in the strict sense, or resident aliens. All such persons are subjects, all being subject to the power of the state and to its jurisdiction, and as owing to it, at least temporarily, fidelity and obedience. Okay, and that's Black's 8th dictionary. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it, they must defend it. Although they do not enjoy all the rights of citizens, they have only certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. And this is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. So if you think about it, people that are here, immigrate here, and they have children here. The children are, because they're born here, are U.S. citizens, but they're still a subject, okay, because they're talking about it right here. Their children succeed to their status, for the right of perpetual residence given to them by the state passes to their children. And that's why they put that section in the 14th Amendment. Contact information. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo.com. My YouTube profiles, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it because of censorship on the part of Facebook. My private group, Sovereignty International on Facebook, is being deleted. It takes time to ban 17,000 people off your group. And I'm not going to let Facebook profit from my hard work. My Yahoo private group is Administering Your Public Servants. My Google private group is Administering Your Public Servants. One does not necessarily become a non-resident by absenting himself from his place of abode, and that's the Missouri Court of Appeals. In other words, it's all in what you tell them, okay? It's all in what you tell them. Resident is a noun, a fact of being officially resident, a statutory presence of an incumbent in a benefice. That's Funk and Wagnall's dictionary. It might be correctly said there is no such thing as a citizen of the United States. A citizen in any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. So a U.S. citizen's a fraud, okay? And that's what these bail priests do, is they get you to participate in their fraud, and then they use that to violate your rights. Every taxpayer is assessed to a trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Slater's protestations to the effect that he derives no benefit from the United States government have no bearing on his legal obligation to pay income tax. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. And this is the D.C. Code, located at Chapter 56, Section 1617, at 31 Stat 1432, the legal estate to be in necessitake use. And this is more D.C. Code, which was approved March 13, 1901 by the 56th Congress, 31 Stat 1189, and Section 2 right on the front. It says, be it further enacted that the interpretation and construction of said code, the following rules should be observed, namely that the word person shall be held to apply to partnerships and corporations. More D.C. Code, talking about absence for 7 years, Section 252, located at 31 Stat 1230. And it talks about the presumption of death, okay? And so they can presume you're dead, okay? And that's the dead is the necessitake trust. It's a dead thing. And this is Title 15, United States Code, Section 44. This is where it's codified. Corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest, and it goes through the same definition except it doesn't have shares of capital stock or certificates of interest. Okay, so did you give up your God-given rights for some satanic privileges? Okay, that's the Sestake Trust is what they're talking about right there. And the Sestake Trust comes from the Roman cult. This is taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use and receiving the actual profits, while a season of the land remained in the nominal fiefie, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks, to be bound in conscience to account to his Sestake use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Well, in 1835, it was the foundation of modern conveyancing, is still the foundation of modern, and they use it for a whole bunch of other things too. So we're going to talk about some court cases that talk about race, and I've already kind of alluded to this. The court cases about race they used to talk about what was considered subjects. Because of the so-called 14th Amendment, all subjects became U.S. citizens. See the so-called 14th Amendment is unconstitutional video because it's actually a revision. See the slavery equals Roman cult video. Slavery was introduced in America as a mechanism to enslave everybody, and that's exactly what they've done. Okay, unless you're really on top of it. I mean, most everybody out now nowadays is enslaved, and they don't even know it. But they are sovereigns without subjects, unless the African slaves among us may be so called. That's Chisholm versus Georgia, and that's back in 1793. No black or mulatto person or Indian shall be allowed to give evidence in favor or against a white man. Okay, this is all basically racist court cases from before the Civil War. The words Indian, Negro, black, white are generic terms designating race. Therefore, Chinese and all other people not white are included in the prohibition from being witnesses against whites. Okay, so again, I think it's the Roman cult was involved in this, and also, in my opinion, the Masons. Okay, because Albert Pike was a Confederate general, and he was also a very prominent Mason and Luciferian, and he actually wrote a book called Morals and Dogma, and in there he talked about the 3 world wars, and the First World War happened just like he said, the Second World War happened just like he said, and the Third World War is getting ready to happen just like he said. And so whether it does or not, maybe we can put a stop to it, but the bottom line is that all of this stuff was orchestrated, and we cannot, if the rights of the least of us are violated, then we're all diminished, and we have to put a stop to this stuff. Excluding Chinese witnesses in suits to which white persons are parties is affirmed. The indicium of color is not an infallible test of the competency of a witness under the act, excluding blacks, mulattoes, and Indians from testifying for or against white persons. Okay, and so, I mean, how do you tell when somebody's white anyways? I mean, man, there's so many, I mean, get real. I mean, this is all just a bunch of garbage is what it is. In a criminal action against a white person, a black or mulatto person, although the injured party cannot, under the statute, be a witness against the defendant. The words in favor of or against any white person in the act prohibiting persons of one half or more Indian blood or Mongolian or Chinese from giving evidence refer to the defendant alone in a criminal action. And so, again, this is all just it's a bunch of Masons, okay, a bunch of Satanists that are using it to enslave people is what it is. The 14th Amendment to the Constitution of the United States does not conflict with the power of the legislature in the exercise of its discretion to exclude Chinamen from the right to testify in the state courts. And the Crimes Act, as amended in 1863, provided that no Indian, Mongolian, or Chinese shall be permitted to give evidence in the courts of the state in favor of or against a white man, is not in conflict with the Constitutional Amendment 14, which provides that persons born or naturalized in the United States are citizens, etc., that no state shall make any law abrogating the privileges or immunities of the citizens, nor deprive any person of life, liberty, or property without due process of law, nor deny to any within its jurisdiction equal protection of the laws, since the restrictions by such amendment imposed on states relate to substantial personal rights of liberty, property, etc., and do not extend to mere rules of evidence. And so, again, this is all a bunch of Masonic, satanic garbage. The evidence of a Chinaman cannot be admitted to prove a white man guilty of manslaughter, and this is the kind of stuff that happens, okay? And that's why we need to, when the rights of the least of us are violated, we are all diminished, and we cannot allow this kind of stuff to happen. The right of trial by jury in civil cases, guaranteed by the 7th Amendment, and the right to bear arms, guaranteed by the 2nd Amendment, have been distinctly held not to be privileges and immunities of citizens of the United States, guaranteed by the 14th Amendment against the abridgment by the states. And in effect, the same decision was made in respect to the guarantee against prosecution, except by indictment of a grand jury, contained in the 5th Amendment, and in respect to the right to be confronted with witnesses, contained in the 6th Amendment. And so, that's U.S. Supreme Court, okay? And that's basically saying that U.S. citizens don't have any rights, but you can be a state citizen. I don't care what color you are. You can. The technical niceties of the common law are not regarded. A jury does not figure ordinarily in the trial of an admiralty suit. The verdict of the jury merely advisory and may be disregarded by the court. The rules of practice may be altered whenever found inconvenient or likely to embarrass the business of the court. Yeah, we want to railroad this guy, so let's just throw these rules out and just go ahead. And it's a kangaroo court. It's bought and paid for. A court of admiralty acts upon equitable principles. Yeah, right. But it's satanic. Okay, because the bail priest is sitting up there and he's playing stupid. A libel of information does not require all the technical precisions of an indictment at common law. If the allegation describes the offense, it is all that is necessary, and if it is founded upon a statute, it is sufficient if it pursues the words of the law. And that's actually an old court case. That's like early 1800s, maybe even late 1700s. The Congress shall have power to dispose of and make all needful rules, regulations respecting territory or other property belonging to the United States. Okay, and that's U.S. Constitution, Article 4, Section 3, Clause 2. That's what a U.S. citizen is other property belonging to the United States. It's not mine, okay? I'm not having anything to do with it. I don't give them evidence of it, and I avoid it like the plague. This is a letter from the Georgia Department of Driver Services. It's been sanitized is what I want to say, but it's sanitized, I suppose. It took the name off of there. The important part is up here on the second page, and I have the text here. This is the whole letter, and there's the signature. But anyways, and I have the text here that I want to bring your attention to. The statute creates a rebuttable presumption of residency for anyone who meets the following criteria. And so, I mean, it's any statute creates a rebuttable presumption of residency for any who meets the following criteria. However, no such person shall be considered a resident for purposes of this chapter unless such person is either a United States citizen or an alien with legal authorization from the U.S. Immigration and Naturalization Service. And that's from the General Counsel of the Georgia Department of Driver Services. Statutes do not apply to state citizens, and that's the point, okay? I cannot delegate authority to regulate you, and therefore neither does the government, okay? It's a contract. Statutes are for U.S. citizens, which is really government employees. That's the contract. You're working for the government. There have always been two classes of citizens. The citizens of each state shall be entitled to privileged immunities of several citizens in the several states. That's in U.S. Constitution, Article 4, Section 2, Clause 1. And the amendments, it even talks about it. But the stranger that dwelleth among you shall be unto you as one born among you. Thou shalt love him as thyself, for you were strangers in the land of Egypt. That's how they enslaved the children of Israel, okay? And that's exactly what they're doing today. The more things change, the more things stay the same. Love ye therefore the strangers, for ye were strangers in the land of Egypt. And we call ourselves Christians. We are Satanists. Mark Passio is right. 2/3 of Americans are practicing Satanists. We're supposed to be not doing this stuff to the strangers, to the people that are coming here. And we call ourselves Christians. I think it's more like about 90% of us are Satanists. The rights of sovereignty extend to all persons and things not privileged that are within the territory. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, and also to those whose residence is transitory. All strangers are under the protection of the sovereign while they are within his territory and owe a temporary allegiance in return for that protection. And that's U.S. Supreme Court. They're talking about the two classes of citizens there, strangers and those born in the land. Strangers have a social security number or social insurance number. Thou shalt not lend upon usury to thy brother, usury of money, usury of victuals, usury of anything that is lent upon usury unto a stranger. Thou mayest lend upon usury, but to thy brother thou shalt not lend upon usury. That's Deuteronomy 23:19-20. The bankster thieves will not loan their so-called money unless you can prove that you are a resident, as in social security number. U.S. citizen does not have access to the first 8 amendments against the powers of the federal government, has no right to trial by jury, has no right to keep and bear arms, has no right to face your accuser, has no right to give evidence against state citizens, has no right to common law indictment, has mandatory military service, mandatory taxes, and may vote, but it doesn't mean anything, has no political power. So why on earth would you want to be a low-life scumbag U.S. citizen? But you can be a national without being a citizen. A citizenship is part of a political community, and this is even showing the U.S. passport application. And I'm going to do a video on American nationals, on how to apply for a passport for an American national. But the oath on the bottom of the thing. It says I'm a citizen or non-citizen national of the United States. Okay, and so again. That's what you need to be as a national, and it talks about it in the application form, non-citizen nationals. And it is, however, true in all common law countries, has always been consistently been held that the wife and minor children take the nationality of the husband and father. That is common law doctrine. That's federal court case. Immigration laws only apply to U.S. citizens and anybody that can get into a contract overseas. Okay. If I am joined in holy matrimony with a girl from Russia, she becomes an American national. She doesn't need their permission, and they know it too. And so that's why they want to get rid. It's also one reason why they want to get rid of this nasty little common law problem, so they can get rid of all these little technicalities and go ahead and do it whatever they feel like doing. In doing this, I shall have occasion incidentally to events how true it is that states and governments were made for man, and at the same time how his creatures and servants at first deceived, next vilified, and at last oppressed their master and maker. Let a state be considered as subordinate to the people, and everything else be subordinate to the state. And that's, again, U.S. Supreme Court, Chisholm versus Georgia, and that's exactly what's going on today, and it's because we, the people, are asleep at the wheel. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and character powers to the state, but the individual rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And this is Acts 22:25-29. And as they bound him with thongs, Paul said unto the centurion that stood by, Is it lawful for you to scourge a man that is a Roman and uncondemned? When the centurion heard that, he went and told the chief captain, the general, saying, Take heed that thou doest, for this man is a Roman. Then the chief captain came and said to him, Tell me, art thou a Roman? And he said, Yes. And the chief captain answered, With a great sum of money I obtained I this freedom. And Paul said, But I was freeborn. Then straightway they departed from him, which should have examined him. And the chief captain was also afraid, for he knew that he was a Roman, and because he had bound him. And so again, okay, if you're the king, okay, you can put them in a real bad position if you know the law. Do you know who you are? In order for a member of the sovereignty to become the subject to regulation anyway, they must agree to it. As with any contract, it must be knowing, willing, and intentional. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private, corporate, commercial paper and securities is concerned. For purposes of suits, such corporations and individuals are regarded as entities entirely separate from government. And that's Clearfield Trust Company versus United States. This is why you cannot pay their extortion, their filing fees in their kangaroo courts. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Okay, all these states have penal codes, and they talk about penalties and offenses. And so we're going to talk about some of those words, okay? Because this is all how they get you into a contract. Again, this is all for U.S. citizens, where an action is founded entirely upon a statute and the only object is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture, to be forfeited for non-compliance with an agreement. Okay, this is the contract. They're getting you into a contract. The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute and brought within the sole object of recovering a penalty or forfeiture imposed as punishment for the specific offense, while a remedial action is one brought to obtain compensation or indemnity. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, and on the other to actions for private injuries in which the party aggrieved may by statute recover punitive damages. Okay, so again, that's why the Satanist clerk masquerading as a judge sits up there and says that when you ask him the nature of the cause, he says it's quasi-criminal. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. Okay, so again, so they all work on presumption. Okay, this is all coming from the UN and the UNIDROIT statute from the UN. Did you give up your God-given rights to some satanic privileges? In an action, this is UCC 3-308, when an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing the validity is on the person claiming the validity, but the signature is presumed to be authentic and authorized. And so, again, what they're doing is they're forging your signature onto a contract. That's what these Satanists do. Okay, this is all coming from the UN. The following rules apply in an action on a certificated security against the issuer. Okay, so they're selling it on Wall Street. Unless specifically denied in the pleadings, each signature on a security certificate or in a necessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine or authorized. That's UCC 8-114. Again, they're forging your signature onto a contract and selling it, securitizing it, and selling it on Wall Street. But individuals, when acting as representatives for a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association over which they are agents or officers, and they are bound by its obligations. Okay, so when you get up there and you say, yes, I am the name, then you just agreed to be a surety for their fictitious entity, for their fraudulently created fictitious entity. Did you give up your God-given rights for some satanic privileges? He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights, except those which the law in its humanity affords him. He is, for the time being, a slave of the state. And that's what they're doing, is they're selling you into slavery. Okay, so again, this is for U.S. citizens. Okay, they have to fabricate evidence of their slave before they can proceed. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. They should be put to death. Okay, that's why they want to get rid of this nasty little common law problem by bankruptcies and various other ways, military occupations, so they can get rid of this little common law problem, because otherwise they would be put to death. Okay, and that's exactly where we, the people, need to go with it. If we want to redeem the land, then we're going to have to shed their blood. The state citizen is immune from any and all government attacks and procedures absent contract. Or as the Supreme Court has stated clearly, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Taxpayers are not state citizens. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision, okay? Whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. The rights of the individual are restricted only to the extent that they've been voluntarily surrendered by the citizenship to the agencies of government. And this is a letter from an Arizona senator by the name of Wayne Stump in 1985. We'll get in a little closer. Notice it's certified. It's come to my attention that numerous individuals in our state have rescinded all of their contracts with the United States federal government, the state of Arizona, and each of its political subdivisions, establishing themselves as freemen under the organic national constitution of the Republic of the United States of America. Consequently, they may be driving without auto registration, driver's license, or any other evidence of contract. Because many law enforcement personnel may be unaware of the contractual nature of auto registration and driver's licenses, it is conceivable that this situation may lead to confrontation between these individuals and law enforcement personnel. I urge you to inform yourself and your personnel about this matter as soon as possible. If you would like to be briefed by someone knowledgeable on this subject, please contact me. In the meantime, inasmuch as this procedure is entirely appropriate when properly carried out, I would like to be personally notified of every such instance of confrontation in order that the persons involved and the public officials involved may be apprised of the correct procedure and the appropriateness of their actions on the part of each concerned. Okay, so again, this is completely appropriate. This is exactly what's happened, is they're getting you into a contract and you don't even know it. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. So how can you lose sovereignty? You lose sovereignty is because of your own ignorance. Ignorance of the law is no excuse. Anytime you get anything from the government, it's an implied contract, and it brings you into their jurisdiction. Anytime you register for anything or make application for anything from the government, you're giving them a power of attorney to make legal determinations for you and represent you. You're making them competent in your affairs. You're telling them that you're a person. You're converting yourself into a slave. All statutes are written very carefully and do not apply to members of the sovereignty. They have to. I actually helped a member of the New Hampshire legislature. He wanted some information on. He wanted to pass a right to travel bill, and one of the things he told me, I supplied him with a bunch of information. But one of the things he told me is that he could not write any bills by himself. It all had to go through this bunch of lawyers, okay, under the legislature, okay? So it goes through lawyers. Members of the Congress or legislature cannot write their own statutes. 99% of the time, the government is technically correct. It's not up to the government to tell you that you're a member of the sovereignty. The government lawyers make up a statute that properly applies to those entities that they have jurisdiction over. The burden's on us to assert our sovereignty. Do you know who you are? Are you going to let some bureaucrat tell you who you are? If a member of the sovereignty gets unknowingly involved in something that operates as a contract by which he might lose his sovereignty, he has made a mistake of law and fact. Whose duty is it to protect the Constitution? The courts have ruled that the government is not the protector of the Constitution. If the government is not the protector of the Constitution, then who is? It's we the people. It's the people who are supposed to be protecting the Constitution. And how do we do it? We do it by challenging what the government does through the courts and administratively, by asserting our rights. The burden's on you to know and understand the law and assert yourself. All contracts must be entered into knowingly, willingly, and intentionally. None of the contracts entered into with the government by which you might lose your sovereignty are willing, intentional, or knowing. The sovereignty of the people is unalienable and imprescriptible. And so, again, do you know who you are? In order to regain your sovereignty, you must assert it. When you assert your sovereignty, you build a case with evidence that you can use in court at a future date should you need to do so. Send all documents by registered mail with a return receipt if possible. See the do-it-yourself estoppel certificates video. The government liars may turn it over to a bureaucrat who may also respond off point. If the government were to admit that you were right, they'd be admitting to treason, extortion, genocide, and other multiple indictable offenses. Okay, so they're never going to admit anything. The government liars will probably not respond at all, and that's a good response, actually. In order to be truly sovereign, you must be self-reliant. You must not only talk the talk, you must walk the walk. You got to be knowledgeable about the law and how it works. You have to be prepared to take the initiative in court if necessary. You have to make it known in no uncertain terms that you're all of the above. It's all about slavery. It's not about race. A U.S. citizen or a citizen of Canada or a citizen of Australia is a slave. Either you're the king or you're a slave, and there is nothing in between. If you participate in their color of law statutes, then you've agreed to be their slave. If you need some bureaucrat to explain the law to you, then you're incompetent and you're a slave. It is only involuntary servitude that's not lawful. You can volunteer in. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be, and Jefferson said it well. Do you know who you are? Nobody said it would easy, but it is possible. If tyranny and oppression come to this land, it will be in the guise of fighting a foreign enemy, and boy, is that the truth or what? What's the alternative? Live free or die. Do you know who you are? Anyways, that's the end of this one on citizenship. Thanks for watching. Spread the word. We need to educate people about what's going on and expose this Roman cult gang to all their Satanism. And have a great day.